Well, I'd like to thank the Carolina Intellectual Property Law Association for this opportunity to present the main ideas behind some comments I'll be filing in the USPTO next month, based on a new perspective on the patent system that departs from and complements the many economic theories of the patent system that inform contemporary patent scholarship. I'd like for us to focus today instead on the ancient and often pejorative characterization of patent law as, quote, the most metaphysical branch of the law, an aspect of patent jurisprudence that proponents of economic theories frequently decry as unreliable and unmoored from policy considerations. My claim to the contrary is that the enduring metaphysical character of patentability jurisprudence is a feature, not a bug, that regards the patent system as entrusted with applying a certain set of ontological and epistemological criteria so as to serve as a repository and gatekeeper of the nation's store of useful knowledge within the meaning of the constitutional patent clause. At a time when partisan disputes over the real and the fake have brought political discourse into a state of ontological and epistemological crisis, the patent system's institutional attention to metaphysical concerns is especially salient. But those commitments have served the purposes of the patent system well from the beginning. When the first patent office opened in 1836, commentators described that purpose in terms of extending the practical reach of everyone. It was only later that microeconomic theory instrumentalized the patent system's contributions more narrowly in terms of shifts in the production possibility frontier, removing the reach of everyone from the equation and raising heavily contested empirical questions about what the costs of patenting and the value of stimulated innovation yield a net economic benefit. But the most metaphysical branch of the law has continued to describe the purpose of patents in the more universal terms of human efficacy, as the Supreme Court emphasized in major patent decisions of the 19th and 20th century. It is for the discovery or invention of some practical method or means of producing a beneficial result or effect that a patent is granted. Human efficacy, or the ability to cause things to happen, is extended by inventions that transcend the natural causal capacities of the human body. As my son knows, the essence of human freedom is the extension of human efficacy without constraint. We aspire throughout our lives to extend our causal frontiers, and the law characterizes state-imposed constraints on our causal frontiers as the severest criminal sanctions short of death and the abridgment of a fundamental right. So when the patent system engages in metaphysical discourse, it is conducting a conversation that is constitutive of a universal and fundamental conception of human freedom, a conversation that serves the necessary translational and truth-giving function of speaking science to the law. A conversation that begins with the inventor's patent claim, a demand that provokes a conversation with the examiner about the eligibility of the claimed subject matter for a patent. And ultimately, a conversation in which the separation of disclosure from property rights in the legal form of a patent reduces transaction costs and facilitates the open sharing of knowledge assets with prospective acquirers, licensees, investors, strategic partners, temporary employees, and outside management consultants. Long ago, a conversation like this wouldn't be as focused on the language of the claim as it is today. The inventor of a machine would have to disclose and specify the invention by submitting a physical model that would be scrutinized by the examiner and added to the patent office's collection. This practice ended around the 1870s as the judicial doctrine of constructive reduction to practice took hold and allowed a paper application to stand in for proof that the claimed invention had actually been made and used. By the end of the 20th century, a production-ready blueprint could stand in for the finished product for purposes of raising the on-sale bar. The Patent Office lightened its load even more by going digital when it moved to Alexandria early in the 21st century. And with the first to file or disclose provisions of the America Invents Act, only acts of public disclosure through the filing of a patent application or otherwise, not those of making or using the invention, will count toward establishing the priority of an inventor's patent claims. So now more than ever, the artifacts on which freedom's conversation are grounded consist of the texts of patent claims and disclosures, divorced from any physical instantiation. Congress has established a comprehensive repository for copyrighted texts, of course, inspired by many of the same public policies that motivated the establishment of the first Library of Alexandria, Egypt, 2,000 years ago. As I have said, the Library of Progress in Alexandria, Virginia, similarly serves as a repository of useful knowledge and as an ontological and epistemological gatekeeper that precedes the kinds of conversations about claimed inventions that the patent system may need to engage in during the lifetime of the patent. Some of these conversations, of course, have ended up in court, the Federal Circuit and the Supreme Court, resulting in written description and patentable subject matter decisions that many scholars and practitioners have found enigmatic and even problematic. But all of these recent decisions, Ariad, Bilski, Alice, Mayo, and Myriad, can be understood under a single unified metaphysical theory as exercises of the patent system's ontological and epistemological gatekeeping functions. Let's begin with Ariad and the written description requirement of Section 112, which the Federal Circuit has described as a requirement to convey the inventor's possession of the claimed subject matter at the time of filing. Now, back in the days of patent models, the notion of demonstrating physical possession of the invention at the time of filing was easy to understand. But now that the physically disembodied text of the patent application is all there is, and all that counts to priority, what does it mean for the inventor to convey possession of the claimed invention? As Jeff Lefston has pointed out, on its face, this doctrine does not appear to be syntactically sensible. But let's think about the patent system's ontological gatekeeping function in the context of the written description requirement. Let me illustrate by first considering a very poor ontological gatekeeper. So I've never had a pet dog in my whole life, but if I were to call a telephone psychic who was charging by the minute and asked her to help me find my lost dog, Rover, she'd be more than happy to converse with me for hours about a non-existent pet. The psychic's technique, known as cold reading, says that if I talk as if Rover really exists, the psychic should commit to talking as if she believes Rover exists too. So in metaphysical terms, cold reading demands that the psychic take on whatever ontological commitments are expressed by me, the client, in the course of our conversation, even when those commitments are not warranted in fact. Patent examiners can't afford to take such a permissive approach to ontological gatekeeping. Every patent claim is a demand that the patent office, the courts, and the public talk about this new kind of entity described in the newly coined language of the claim, not for a few minutes, but for the next 20 years. That's quite a commitment. It's an ontological commitment. And therefore, at a minimum, the gatekeeper should insist that the patent disclosure demonstrate the inventor's ontological possession of the claimed invention. That is, when the inventor discloses the invention in writing in the specification, she does so out of a good faith ontological commitment to the existence of the kind of embodiment described in the claim language, whether or not any particular embodiments actually exist. This commitment to kinds, but not to particulars, is what philosophers refer to as the kind of de dicto ontological commitment from which the inventor can demonstrate ontological possession of the claimed subject matter as of the filing date. Some claim terms might give the examiner pause. For example, no one has ever directly observed an electron. There are good reasons to believe that no one ever will. They're just too small. So when it was filed, this claim, which refers to the work required to withdraw an electron from a metallic emissive insert in an arc welding torch, demanded that the federal circuits open their door for 20 years to hear infringement cases alleging that an accused device exhibited a particular phenomenon for which there can be no first-hand witness. There was, in fact, a lawsuit on this claim and expert testimony about the work functions of different metals, and no one at any point was bothered about the invisibility of electrons because there's a well-established, generally accepted scientific theory of electrons and their effects, so that thousands of patented inventions that purport to utilize the effects of electrons can recite the word electron, and accused devices can be found to infringe on the basis of those theorized effects, even if no one will ever be able to point out the accused electron on which the claim term reads. In accepting electrons into the patent system's ontology, the examiner is not practicing cold reading like the psychic, and they're not falling down on the job of gatekeeping. Rather, she is observing the criteria for ontological warrant associated with scientific realism, which holds that if the world behaves as if an unobserved entity exists, the best explanation is that it does exist. So we're warranted in believing that the wind was blowing when this picture was taken, even though we weren't there, we didn't feel the wind, we didn't directly observe the wind, because we can observe the effects as they appear in the photograph. Scientific realism also gives warrant to the Patent Office when it accepts an inventor's written account of how to make and use an invention that presupposes the existence of electrons without a physical demonstration. As long as the inventor's assertion of the invention's results or effects is not incredible in light of the knowledge of the art or factually misleading. So we can respond to Jeff Lefston's puzzlement over the written description jurisprudence of Ariad simply by recognizing that the requisite possession of the claimed subject matter is of the ontological kind, which is reasonably conveyed and accepted into the ontologies of those skilled in the art under the warrants of scientific realism. Thus, the Patent Office is engaged in an ontological building project, one patent claim at a time. It manages this project in part through a classification system that routes applications to examiners and aids those examiners in locating pertinent prior art, giving the Patent Office as a Library of Progress more than a passing resemblance to the Library of Congress, which has its own classification that routes books to their locations in the library itself and thousands of other libraries across the country, aiding patrons in browsing and reading them. Of course, compared with most of the browsing and reading we do in the library, transactional disclosure and patentability and infringement analysis are much more demanding textual inquiries, requiring a more exacting approach to ontological gatekeeping. Remember again that the patent applicant is demanding that for the next 20 years the patent system entertain legal arguments about the subject matter of the claim that are grounded in the discursive nature of patentability doctrine. To admit a claim that entails an ontological mismatch in patentability discourse is to commit the patent system to talking nonsense. This is the most famous teaching example of that kind of nonsense, of an ontological mismatch, also known as a category mistake. Colorless green ideas sleep furiously. Ideas, of course, are not the kind of entity that can be green or sleep. Sleep is not the kind of activity that can be done furiously, and green is not the kind of attribute that can be colorless. Right? So this sentence has no intelligible meaning, as linguist Noam Chomsky pointed out. So if a claim entails an ontological mismatch in patentability discourse, it commits us to speaking nonsense, better to bar it at the door. Better to bar it before it causes problems with talking about the subject matter of the patent as we examine it under other headings of the law. So for this purpose, then, it would be helpful if Section 101 of the Patent Act served as some sort of ontological mismatch bar. So let's turn to Section 101 now, which provides that processes, machines, manufacturers, and compositions of matter are all patent-eligible categories of inventions, but subject matter that nominally falls into one of these categories may still be subject to one of the judicially created exclusions from patentable subject matter, laws of nature, natural phenomena, abstract ideas. Patent claims directed to any of these excluded categories are barred at the door by Section 101, obviating further analysis for novelty and non-obviousness under Section 101 or 102 and 103, according to the classic formulation of Chief Judge Giles Rich of the Federal Circuit. An important gloss on this threshold function of Section 101 was given by then future Chief Judge Randy Rader's concurrence in Bilski, which was the only part of a deeply splintered Federal Circuit en banc opinion cited with approval in the Supreme Court majority opinion in that case. In reviewing a software implemented process from the abstract idea exclusion from patentable subject matter, Judge Rader urged an approach that would preview the doctrinal inquiries for novelty under Section 102 and 103 and ask whether the claim, quote, appears in a form that is not even susceptible to those inquiries. So in particular, Judge Rader's approach characterizes Section 101 patentable subject matter as a threshold inquiry that preempts subsequent patentability analyses that would result in ontological mismatches. In re Allopat, another high-profile Federal Circuit decision on the patentability of software, Judge Rader's predecessor, Chief Judge Glenn Archer, highlighted the ontological mismatches that subsequent patentability analyses would necessitate if E equals MC squared had been held patentable and had not been barred by Section 101. We'd end up asking, how would we analyze that for non-obviousness? Is E equals M squared, is MC squared non-obvious? When is it reduced to practice? All of these nonsense inquiries. What conduct amounts to the infringement of E equals MC squared? Very nonsensical kinds of questions that we don't have to answer because it's barred at the door by Section 101. So in Judge Archer's words, subject matter eligibility lays the predicate for the other provisions of the patent law. Interestingly, though, an ontological mismatch in the Section 103 analysis was the original sin that opened the doors for software patenting for Walter Bernhardt, the developer of a 3D graphics program for Boeing, who was awarded what commentators at the time referred to as the first true software patent. Bernhardt's program performed the calculations necessary to project points in three-dimensional space onto the coordinates of a two-dimensional display screen based on a set of equations that was simpler than a set of equations for a similar projective transformation appearing in a prior art patent directed to a system in which the calculations in question were performed by a special purpose circuit rather than a programmed general purpose computer. As it turned out, Bernhardt's application landed on the desk of an exceptionally dedicated examiner at the Patent Office who wrote out 6 pages of algebra demonstrating that the two sets of transformation equations were in fact equivalent and accordingly rejected Bernhardt's claims as obvious over the prior art. Judge Donald Lane, however, found the math more impressive than the legal argument. He described the examiner's algebra as a hindsight reconstruction that could not have been performed without prior knowledge of Bernhardt's simpler equations by one of ordinary mathematical skill. He actually used those words, ordinary mathematical skill. But framing the Section 103 non-obviousness inquiry from the standpoint of one of ordinary mathematical skill presupposes that the art to which the claimed invention pertains is mathematics. But mathematical results are categorically and paradigmatically unpatentable. Once Judge Lane found himself looking at Bernhardt's equations and asking, how hard was the math? He should have stopped short and realized that the inquiry entailed an ontological mismatch. In Judge Rader's words, Bernhardt's claims were not even susceptible to examination against the prior art equations under the traditional tests for non-obviousness. Section 101 should have barred them at the door. But instead, Judge Lane characterized Bernhardt's claims as directed to a new machine or a new and useful improvement of an unprogrammed machine, and therefore patent eligible, a characterization that would eventually take hold in Allopat, which we've talked about earlier, and dominate the Federal Circuit's jurisprudence until Bilski and Alice came along. In Alice, the Supreme Court most recently considered the patentability of software and held that a wholly generic computer implementation of an abstract idea, such as intermediated settlement of financial obligations, was as patent ineligible as the abstract idea itself. In reaching this result, the court applied the two-step test from Mayo versus Prometheus, which I'll discuss in more detail in a moment. The test itself rules out the judicially recognized exceptions, as well as other claims that contain additional elements that do not, quote, amount to significantly more than the judicial exception, so as to save the claim from exclusion under Section 101. It's not immediately clear that Bernhardt does not survive Alice, as Bernhardt's mathematical equations are quintessentially abstract ideas, and the other elements of Bernhardt's claims are expressly described as generic computer implementations. So Alice serves to finally correct the original sin of Bernhardt, whereby Section 101 would now obviate Judge Lane's inappropriate inquiry into how hard the math was. But unfortunately, the Alice Court itself does not acknowledge Section 101's role in avoiding ontological mismatches in patentability analysis. Instead, Justice Thomas writes for a unanimous court that the animating principle of Section 101 jurisprudence is the concern that the basic tools of scientific and technological work will be preempted by claims that are not sufficiently distinguished from laws of nature, natural phenomena, and abstract ideas by, quote, additional elements that amount to significantly more. But as Kathy Strandberg notes, the court's preemption rhetoric does not fit the court's actual jurisprudence or avail itself of a sound theory. I contend that my unified account of the court's Section 101 jurisprudence as a threshold inquiry that obviates subsequent patentability analysis that would result in nonsense, ontological mismatches, is a better explanation and justification for the court's decisions in Bilski and Alice. Simply put, Section 101 is best understood as the ontological mismatch bar, at least after Alice. And if I'm right about that, then behind every Section 101 rejection, there should be a latent ontological mismatch that was avoided. So what about Mayo itself? Where's the latent ontological mismatch there? Well, there's an ontological mismatch, but it's not the kind that comes up in patentability analysis unless you're working late on it and making yourself a snack. But the ontological mismatch in Mayo actually comes up in the Section 112 analysis that never happened. So these are the clinical pharmacokinetic data that underlie the patented invention at issue in Mayo, which was a method for alternately dosing a patient with Crohn's disease and then testing the patient's blood to maintain a concentration of a particular metabolite in the blood in the safe and effective range identified by the inventors in the previous slide. So after formulating this two-part test, the court looked at the wherein clause in the claim and said, that's just a statement of the natural law that the safe and effective concentration of the 6-TG metabolite for treating Crohn's disease in the human is between 230 and 400 picomoles per 8 times 10 to the 8th red blood cells. They called that a law of nature. If you call that a law of nature, there are a lot of more laws of nature than any of us were taught in school. Right? But that's step one. Step two asks whether the additional elements in the claim amount to significantly more than the law of nature we just looked at. But the court says no. The instruction to doctors to apply the applicable laws when treating their patients does not add enough to the claim. Now remember that Mayo is the paradigmatic case for calibrating whether you've added something more to the claim or not. So it's worth taking a careful look at the court's gloss on these additional elements as a mere instruction to doctors to apply the applicable laws, and why the court found that to be inadequate as a teaching, thereby calling to question the disclosure function of the claim, which after all does count as part of the patent specification. So reviewing the claim as part of the patent disclosure under the enablement standard, we would ask, what teaching enables a person having ordinary skill in the art, that is a doctor who's reading the claim, to practice the method that's recited in the claim? And the Mayo Court's step two analysis gives the answer. It says the teaching of the method steps A and B in the claim don't amount to much, really. What I'm going to show now, though, is that it's a teaching, but it's not the kind of teaching that fits the enablement analysis. It's the kind of teaching that leads us into a nonsensical analysis. It's an ontological mismatch, and so the Mayo Court was right to stop at 101 before it got to the 112 analysis. Now, the enablement standard requires that the patent specification disclose the invention to a point that one of ordinary skill in the art who reads the patents will know how to make and use the claimed invention. Enablement case law allows that the teaching may leave a reasonable amount of trial and error as an exercise for the reader, as long as the amount of experimentation is not undue. So the enablement standard is met by a specification whose teaching obviates the undue experimentation that would otherwise be needed by a person having ordinary skill and knowledge of the pertinent prior art to make and use the claimed invention. So what kinds of teachings can do that? Teachings from experience, otherwise known as a posteriori knowledge, results from experiments, randomized trials, observational studies, as well as the kinds of inductive inferences from those kinds of experiential results that would be accepted under the patent system's criteria for ontological warrant. Okay, that's the kind of knowledge that substitutes or is capable of substituting for undue experimentation. What kind of teaching can't substitute for experimentation? The other kind of knowledge, a priori knowledge, whose categories include the judicially excluded categories of unpatentable subject matter, laws of nature, abstract ideas. Also tautologies and deductive inferences from stipulated facts. The steps of Mayo's claims fall under this category, and Mayo's claim fails for this ontological mismatch with the enablement inquiry. The additional elements are teachings, but they're not teachings from experience. Now, my gloss on Mayo still requires you to accept the court's premise that the safe and effective concentration of a non-naturally occurring metabolite, being between 230 and 400 picomoles per 8 times 10 to the 8 red blood cells, falls under the category of a priori laws of nature. Right? The characterization is scientifically dubious. The inventor's clinical data, very few data points here, don't come anywhere near supporting the degree of reliance that the scientific community typically reposes on natural laws. But setting the statistical quibble aside, the empirical provenance of the recited thresholds of 230 and 400 does not serve, at least on its own, to destabilize the court's doctrinal distinction between a priori and a posteriori, a phenomenon of nature, and patentable subject matter, because as the court reiterated in Mayo, a new empirical discovery of a phenomenon of nature is not patentable by virtue of its empirical provenance. So as our understanding of Section 101 as an ontological mismatch bar serves to elucidate Mayo Step 2, which David Taylor has described as purely subjective as to when additional elements amount to significantly more than the judicial exception. Abstracting a holding from the court's statistically problematic characterization of Mayo's facts, we end up with a test that is stable as the most fundamental categories of human knowledge. The dichotomy between a priori and a posteriori, or contingent and necessary truths, known to philosophers through the ages as the Humean fork, which include natural causes under the patent system's worldview of scientific essentialism, an ontological stance that had already been articulated by the Supreme Court in the patent system's formative years. Armed with this Humean fork, we now have a clear view of the ontological mismatch in enablement analysis resulting from the Mayo claims tautological application of a natural cause, and the Alice claims deductive conclusions from stipulated facts about a computer system. So the 101 rejection of Alice also obviated a latent ontological mismatch in Section 112 enablement analysis that would have been fatal to the project of building a library of progress. Finally, here's the grand challenge, myriad. Where is the latent ontological mismatch in myriad? So myriad was a split decision. It was heavily criticized. From the standpoint of molecular structure, an isolated DNA oligonucleotide and a cDNA oligonucleotide that happen to have the same base sequence are chemically identical. They're the same molecule, differing only in how they were made. But the Supreme Court held that the first kind were not patent eligible, and the latter composition of matter was patent eligible. And commentators like Gregory Dolan looked at the opinion, found it incoherent and lacking any explanation for the two different approaches. Well, Neil Katyal's oral argument is as good a place to start as any. In arguing for the patent ineligibility of isolated DNA, Katyal asked the court to imagine a, quote, magic microscope powerful enough to zoom in on a naturally occurring strand of genomic DNA to the point where the claimed oligonucleotide sequence would be isolated from the viewer's perspective in the microscope's field of view. So in contrast, the sequence of a cDNA oligonucleotide formed by splicing out the non-coding regions of a genomic DNA sequence typically would not appear as a contiguous subsequence of genomic DNA that could be isolated in a microscope's field of view. For an analogous argument, I commend an article by Professor Connolly that was cited with approval by the district court in the Myriad case. Unbeknownst to everyone in the courtroom that day, Katyal's argument had already been bolstered by dramatic advances in microscopy during the pendency of the Myriad case. Bart Hugenboom was able to discern the sequence of DNA molecules by imaging the mechanical displacements of a nanoscale cantilever that was bumping along on the bases that formed the rough exterior of the double helix. This was a mechanical imaging device. And Enzo Di Fabrizio looked at light diffraction, and he was able to sequence DNA molecules by measuring the displacements of an electron beam that was being fired at the molecules. So both of these imaging techniques are admissible to inform the patent system's ontological gatekeeping under the doctrine of scientific realism. Both of these are photographs of wind blowing, right? You can image the effects, the mechanical effects of bouncing on the side of the molecules or of deflecting an electron beam. So they're not direct observations of DNA, but of its effects on nanoscale cantilevers and electron beams. And so distilled to its essence, then, this is Katyal's test. And we can even dispense with the magic microscope notion and ground the test in precedent. So our explanation for Dolan for the difference between the two approaches is The isolated DNA produces the same relevant effects, that is, sequence-specific hybridization, as the corresponding genomic DNA that occurs in nature, while cDNA generally does not. There's your distinction. So nearly 2 centuries after Justice Woodbury's description of patent law as the most metaphysical branch of all the law, modern patent jurisprudence remains deeply steeped in metaphysical analysis, especially in the area of patentable subject matter doctrine. This analysis does not serve to advance economic or other policy objectives, to the consternation of many of the other commentators with whom I've engaged here, but to realize the legal construction of the patent system as a library of progress in respect of the most essential of human freedoms, that of unconstrained efficacy. It does this by enforcing sound and stable criteria for admitting new kinds of products and processes into the special conversations that take place in the library about patentability and infringement, transactions and teamwork, conversations that are ultimately about freedom, the freedom to operate. And it bars at the door patent claims that would divert those conversations into nonsense, into ontological mismatches. Fruitless inquiries into how hard the math was, or how much experimentation is needed to confirm that water is H2O. Thus, as it turns out, modern patentable subject matter doctrine, ostensibly opposed to preemption, engages in a bit of preemption of its own. It banishes navel-gazing, which isn't often said about metaphysics. Technology is distancing humans from a time when it is necessary for we ourselves in our bodies to be the change that we wish to see in the world. We can now cause changes in the world at great speed and at great remove. Today, conversations about American progress are predicated on extensions of human efficacy that would defy the imaginations of the founders. In Ariad, Bilski, Mayo, Allison, Myriad, the Federal Circuit and the Supreme Court have laid the 21st century foundations for a library that can manage the whole world's conversations about how best to bring about those beneficial results and effects. Yes, in this library you are invited, encouraged, and dare I say it, incentivized to have those conversations in an ever more diverse and demanding vocabulary. Conversations about freedom and progress, conversations about the useful arts in as many senses of the word useful as the human mind can conceive. Conversations about our aspirations and our struggles to cause the changes we wish to see in the world, as solitary individuals confined in our own time and space, and as an intertemporally and globally connected species. I've enjoyed this brief moment of local connection with you, not inside the Library of Progress, but well within the shadows that embody its observable effects. I hope I've conveyed the broad contours of that edifice with sufficient descriptiveness and warrant that you have admitted this Library of Progress into the ontology of your discourse. Thank you.